In this series of lectures on legal profession, already we have dealt 9 lectures on relating to legal profession in particularly legal ethics, legal conduct, and legal or professional misconduct and those punishments and the organization and institution, composition, the power and functions of State Bar Council and Bar Council of India, also the rights of advocates and duties of advocates which are falling under professional conduct. And in this 10th lecture, which would be the final lecture on legal profession, we would like to discuss certain important landmark judgments relating to professional misconduct. And in that regard, we would like to discuss the first one, that is P.D.Gupta versus Ram Murthy. So, in the very case, the very fact is that one Sri Krishna Das died leaving some property of which a Vidyavati, claiming as his sister and legal heir, and claims the very property under section 276 of the Indian Succession Act before the District Judge Court, Delhi, and some complainants like Ram Murthy and 3 others, they challenge the very claim of Vidyavati. So, in that particular litigation, P.D. Gupta, who was the counsel of Vidyavati, purchased the said property. So, the very complainant, Ram Murthy and 3 others, they went to the disciplinary committee of the Bar Council of Delhi, and under section 36B of the Advocates Act, it was transferred to the disciplinary committee of the Bar Council of India, which held him guilty of professional misconduct and suspended from practice for 1 year. Then P.D. Gupta filed an appeal before the Supreme Court under Section 38 of the Advocates Act. But the apex court overruled the order of the Bar Council of India. And now we would like to discuss another important leading case, which was Sumoto, held by the apex court, where Chief Justice Dr. S. Anand and Justice Srinivasan and Justice Jain Santosh Hegde, they held the provisions of Section 49, Section 12 of the Contempt of Courts Act of the number 70 legislation of the 1971. Also, Article 129 of the Constitution on the very issue that the complainant shouted slogan in open court and hurled his suit towards the court, and it was held as criminal contempt. So, the court announced simple imprisonment for 4 months and a fine of Rs 20,000 to Nandalal, who was accused and of the member of the Bar Association of Bombay, and the very issue why the court held as intimidating the court and interference in the judicial proceedings, so it is a kind of professional misconduct as it was held by the apex court, and in another important leading case, that is relating to Ishwar Prasad Arya's case, where it was relating to Section 307 of the Indian Penal Code and Section 25 of the Arms Act, which were applied, and the very session judge announced 3 years rigorous imprisonment for under the Section 307 of Indian Penal Code and 9 months for Section 25 of the Arms Act. High Court upheld Section 307 of the Indian Penal Code, but Section 25 was set aside under benefit of doubt, as the very letter forged by the respondent from Governor of UP to the third additional district session judge, and the very complaint to the chairman of Bar Council of Uttar Pradesh. So the disciplinary committee under Section 735 of the Advocates Act appealed to Bar Council of India, and disciplinary committee of the Bar Council of India set aside the order of the UP Bar Council. So the appellant Hikmat Ali Khan wrote a letter to the Secretary Bar Council of UP, disciplinary committee of the Bar Council of Uttar Pradesh, but an appeal to the Bar Council of India was made, and the disciplinary committee of the Bar Council of India set aside the orders, and an appeal was filed in Supreme Court under Section 38 of the Advocates Act 1961, and the apex court ordered removal of his name from the state roll of the advocates. And now we would like to discuss another important leading case, and that is relating to Shambhu Ram Jadhav versus Hanuman Das Khatri, where it was a complaint filed against the respondent advocate by complainant petitioner before the Bar Council of Rajasthan was referred to the disciplinary committee of the State Bar Council of Rajasthan. It stated that the respondent, as his counsel in a suit, wrote letter to his client, inter alia stating that his own client has told him that concerned judge accepts bribe, and he has obtained several favorable orders from him in his favor. He may send arrest 10,000 so that through the said client the suit is got decided in his favor. This letter is not disputed. The disciplinary committee of the State Bar Council held that, keeping in view the interest of litigating public and legal profession, such practice, whenever found, has to be dealt with in an appropriate manner, holding the respondent guilty of misconduct under Section 35 of the Advocates Act 1961. The State Bar Council suspended him from practice for a period of 2 years with effect from 1997. The said order was challenged before the Bar Council of India in an appeal. The disciplinary committee of the Bar Council of India enhanced the punishment and directed that the name of the respondent be struck up from the roll of advocates, thus debarring him permanently from practice. The respondent filed a review petition under Section 44 of the Act against the order. It was allowed, and earlier order was modified by substituting punishment with one of reprimanding him. The reason given in the order, among others, was that the petitioner, respondent, is an old man of 80 years. He joined profession in 1951. It was for first time that he committed hereby in such an irresponsible manner, although he had no intention to bribe. In an appeal under Section 38 of the Act, the Supreme Court held that the bar councils under the Advocates Act have been entrusted with the duty of guiding the professional ethics. They have to be more sensitive to the potential disrepute on account of action of a few black sheep, which may shake the credibility of the profession and thereby put at stake other members of the bar. Considering these factors, Bar Council had inflicted in its earlier order the penalty under these circumstances. It has no hesitation in setting aside the order of 2000 and restoring the appeal order of the Bar Council of India. And in our next important case, that is relating to Srimati Urmila Devi versus Sita Ram Singh, which we would like to discuss in our next important leading case, that is falling under professional misconduct. So in this particular case, the complaint was a money lender duly registered under the Money Lenders Act. She engaged the respondent advocate named Sri Sita Ram Singh as her counsel for filing many money suits against her borrower, and several suits were declared. She paid the advocate court fees, counsel fees, and other expenses. The complainant alleged that the said advocate used to withdraw the amount from the courts from time to time without the consent and knowledge of the complainant. Initially, in his written statement, the advocate admitted that he had withdrawn the amount, but thereafter he amended statement. He denied it. In view of the admission, it was for the advocate to prove that he had not withdrawn the amount. The disciplinary committee of the Bar Council of India came to the conclusion that though the exact amount withdrawn by the respondent advocate was not proved, but certainly some amount were withdrawn by the respondent advocate, and he failed to account the same to the complainant in spite of the notice. This conduct of the respondent advocate was professional misconduct. The committee expressed the view that whatever money was withdrawn was not paid to the complainant in spite of demand made by her. The committee found that notice was given to the complainant to the advocate to furnish accounts for the amounts withdrawn. But this notice was not replied by the advocate. In the opinion of the committee, failure on the part of the advocate in replying the notice or furnishing the accounts for the amount withdrawn was professional misconduct. So the committee held the respondent advocate withdraw Rs 40,000 in all, and therefore he should pay this amount to the complainant within a period of 2 months. The committee held, since he was inflicted sentence of suspension In another case, for a period of 1 year, the same punishment is imposed in this case, and the suspension of both the cases would run concurrently. The committee held that the cost of the case, that was as 5,000, would be paid by the respondent advocate within 1 month, failing which he had to undergo suspension for another 1 year. And now we would like to discuss another important leading case relating to professional misconduct, and that is MS Padavardhan versus V.V.Karamarkar. So, in this case, the complainant decided to purchase 100 acres of land through a real estate agent for undertaking an agricultural development project by forming a cooperative society. The complainant engaged the respondent advocate for completing the necessary legal formalities. He was paid Rs 2,45,000 for the purchase of land, stamp duty, registration charges, and other expenses. The respondent, in spite of the request, did not render the account and did not pay the balance amount lying with him. Initially, the respondent advocate denied that he had received the said amount of Rs 2,45,000, but ultimately, at the stage of evidence, admitted that in all he had received Rs 2,45,000 from the complainant. It was also found by the committee that the respondent had not handled the work in a proper manner. The complainant did not do the entire work for completing the transaction with various farmers due to the failure of the respondent in rendering the accounts. After examining the statements made by the respondent and other relevant documents, the committee came to the conclusion that the respondent had failed to give to the complainant account of expenses and fees. He had also failed to refund the complainant the balance amount. He was found to have failed to give the complainant any amount account, much less the proper account. The committee has opined that it is the duty of the counsel to keep accounts of his client's money. It is a settled law that if an advocate fails to maintain proper account of his client's money, he is guilty of professional misconduct. In addition, the committee has made it clear that no advocate is entitled to hold his client's money in his hand. In this case, the huge sum was given to the respondent advocate by the complainant. It was the duty of the advocate to keep account so that he could say what amount he had spent on what account. He was to withhold the complainant's money. The rule of the Bar Council of India makes it clear that no advocate can hold his client's money in his hands. Consequently, the respondent was guilty of professional misconduct. So the committee ordered that the respondent's license to practice be suspended for 5 years and also ordered the advocate to refund Rs 83,000 with interest of 10% per annum. In the opinion of the committee, the amount of refund was Rs 85,000, but since the claim of Rs 83,000 was made by the complainant, The committee directed to refund Rs 80,000 with interest at the rate of 10% per annum. In case the said amount was not refunded, his license to practice was to be further suspended for an additional period of 5 years. And now we would like to discuss another important leading case relating to professional misconduct, and that is Allahabad Bank versus Ishwar Prasad Arya. So, in this particular case, the complainant, Allahabad Bank, filed complaint against the advocate Girish Chandra Verma for misappropriation of court fee and also for not filing cases. It was alleged that 50 suits were not registered as miscellaneous application for want of payment of proper court fees, and two of the suits were dismissed for want of payment of court fees. Out of 52 suits, two suits were not filed at all. Thus, 52 suits were given to the advocate for filing in the court. Out of these 52 suits, 50 suits were filed with nominal court fees and two suits were not filed at all. The advocate misappropriated the sum paid to him by the complainant for the purpose of court fees. It was alleged that the advocate had misappropriated Rs 1,36,000 in total. The complainant claimed the refund of the aforesaid sum and prayed for taking other appropriate action against the misconduct. The committee held that the advocate had misappropriated the amount of court fees of Rs 1,36,000, was guilty of not filing two of the suits. After collecting the court fees from the complainant bank, therefore, the committee ordered for the striking of the name of the advocate from the roll of the Uttar Pradesh Bar Council and refund the amount of 1,26,000 rupees as court fees realized, along with the interest of 9% per annum and the very cost of rupees 15,000. The committee further opined that it would be open to the bank to claim damages for loss due to non-filing of the suits. The committee has made it clear that the legal profession is a noble profession. There are very high expectations from the members of the bar. Therefore, its members must set an example of conduct worthy of. If any of them falls from that high expectations, the punishment has to be with the degree and gravity of the misconduct. So, the committee made its representation that the grant of monopoly of license to practice law is based on three assumptions. The first one, there is a socially useful function for the lawyer to perform. The second one, the lawyer is a professional person who will perform that function. And thirdly, his performance as a professional person is regulated by himself, not mere formally by the profession as a whole. The central function that the legal profession must perform is nothing less than the administration of justice. And now we would like to discuss another important leading case relating to professional misconduct, and that is also Allahabad Bank versus J.P. Srivastav. And in this case, the complaint was filed by the Allahabad Bank against Sri J.P. Srivastav and Sri Navnit Lal Sinha, advocates making the allegations that the respondent number one was engaged by the bank as an advocate for the purpose of filing suits on its behalf in civil courts at Lakshmipur Kheri for conducting such cases and doing all other miscellaneous work, but he misappropriated the court fees and professional fees, etc., received from the bank, and he did not file any case in the court and falsely represented about having filed the suits and also about the dates of hearing. It was also alleged that some cases were filed with nominal court fees while he received full court fees from the bank. He also forged the signature of the branch manager on different applications and affidavits submitted in the court. He sent false information to the branch regarding the process and the very progress of the suit and date of hearing. He wrongfully refused to return to the bank original papers given to him for filing in court and which were not filed. He also threatened to destroy the original records lying with him in case the complainant bank proceeded against him. It was also alleged that respondent number 2 verified the signature of the bank manager forged by the respondent number 1, and he acted in collusion with and aided and abetted the acts of respondent number 1. The above allegations were proved to the satisfaction of the disciplinary committee. The complainant bank suffered huge loss by the act of the respondents. The disciplinary committee held the respondent number 1 guilty of professional misconduct. In the opinion of the committee, he has acted in the violation of professional ethics and prescribed standard of conduct. So, now we would like to discuss another important leading case, and that is S.K. Nagar versus V.P. Jain. So, this is particularly a case where an appeal to the Bar Council of India against the decision of the Bar Council of Rajasthan. The complainant had alleged that he had engaged Sri S.K. Nagar, an advocate, to file a complaint against certain persons for restoration of the possession of the room and articles lying therein. They were in occupation of the room as tenants in the house of the complainant situated at Jawaharnagar. Requisite fees were paid to the respondent, who gave the complainant assurance that the case was being processed and the aforesaid person had expressed their willingness to hand over the possession of the house and needed some time for it. That nothing emerged, and the respondent informed him that the said persons had not appeared in the court and had not delivered vacant possession order by the court. He further informed the complainant that warrant of arrest had been issued by the court and he charged 500 rupees towards the expenses. The respondent told the complainant that warrant of attachment had been ordered by the court against the aforesaid person and got arrest 1000 from the complainant for depositing in court for issue of warrant. The respondent also informed him the date of hearing. The respondent advocate thus gave false information and prepared false and fabricated document to convince the client about pendency of case while no case was filed in the court. He was thus held guilty of professional misconduct. The disciplinary committee of the Bar Council of Rajasthan imposed punishment of 2 years of suspension from practice. The disciplinary committee of the Bar Council of India in appeal enhanced the punishment to in the exercise of the power under section 37 of the Advocates Act. The Bar Council of India imposed a punishment of 5 years suspension from practice along with custom Rs 5,000 to be paid by the respondent advocate to the Bar Council of India. So, these are the landmark judgments delivered either by the Bar Council of India in appeal against the order of the state bar councils and also the appeals filed before the Supreme Court under Article 38 and the very decision of the apex court in relating to violation of professional conduct and committing professional misconduct by any advocate. So, in this lecture, almost we have discussed some landmark judgments, such as the first one, P.D.Gupta versus Ramurthy, then the moto case taken by the apex court in case of Nandalal, and also Ishwar Prasad Arya's case, Shambhu Ram Jadhav versus Hanuman Das Khatri's case, also Srimati Urmila Devi versus Sita Ram Singh, and also M.S. Patavardhan versus V.V.Karamarkar, and two other important leading cases relating to professional misconduct. Those are Allahabad Bank versus Girish Prasad Verma and Allahabad Bank versus J.P.Srivastav. And finally, also, we have discussed the last important leading case, that is S.K. Nagar versus B.P. Jain.